It's my understanding that we've not provided all the information to proceed with the friendly suit.
Okay, let me ask this. Do we have anything else set? Because I'm signing documents and not looking at Odyssey. Do we have a future setting?
Not yet, Your Honor.
Okay. Then I would like to set it for status only. In about 45 days. Is that good enough? Or do you need more time?
If we provide the information that's needed, it's a pretty simple friendly suit.
Sure.
That's quite sufficient time.
Okay. All right. So we'll reset this for a status and friendly suit in 45 days. Okay.
Thank you,
Your Honor.
Thank you.
Have a good day.
You too. Take care.
Bye-bye.
Bye-bye.
Thank you.
Okay.
In cause number 2022 DCV 0886 Eduardo Cabral et al. Versus My Universe Inc. et al. Announcement of counsel, please.
Your Honor, Carlos Rincon for Landstar Ranger.
Good morning.
Good morning, Your Honor.
For Defendant
Morning, Judge.
Expeditors International.
Good morning, Judge. Sebastian Nunez here on behalf of RV Share.
I feel like I missed somebody's name in there because they were over speaking and Deborah Lee's telling me the same thing. I heard Mr. Rincon and I thought I heard Mr. Nunez. Who else did I miss?
Michael Garcia for Defendant Expeditors International in place of Kurt Paxton.
Morning, Your Honor. This is Dan Hernandez on behalf of Kushpa Singh and My Universe.
All right. So we have a final status conference in this case.
Your Honor, the parties had agreed because we are still very early in the discovery process, and please pardon the barking pug. But we're just now in the throes of party depositions, and we had entered into a Rule 11 agreement to secure November 8th, 2024 is the trial date, and we've suspended all deadlines. We'll work out a docket control order. But for example, folks are going to Chicago next month to depose my client. We're deposing the plaintiffs, and some of the other parties are getting deposed, or we're asking for dates. So we just needed to confirm that the trial date was vacated, the one that's upcoming, because I think we've already contacted the court's coordinator, secured November the 8th as the new trial date, and that's the one we're working towards now. And everybody's in agreement.
Let me ask this. I see a motion to compel hearing set for the 24th. Is that still a go?
Yes, there's some good old-fashioned discovery dispute, but it's pretty straightforward, Judge. I think it's a 5-10 minute hearing at most.
Here's what we're going to do. So yes, the March, as long as I'm understanding everyone is in agreement, the March settings and the February setting, February 14th, are vacated. That motion to compel hearing will also serve as our entry of scheduling order deadline. So with that November date that you all have, if you will complete the new scheduling order and have it turned in on that date as well.
Judge, when is that motion to compel hearing set?
January 24th at 10 a.m.
Okay, perfect.
Okay, so
we'll get it done, Judge.
We'll use that date for entry of scheduling order as well, just to make sure we have everything squared away. And that should take care of all our new dates leading up to November. And then, of course, you all can request anything that you need outside of that. Okay.
All right, Judge. That's all we had.
Great.
I know, trying to report. Okay.
Good to see you all. Have a good day.
Good to see you, Judge.
Thank you, Judge.
Happy New Year, Judge.
All right. Who's next? Looking like Ms. Llamas and Mr. Melendez and Mr. Norton. And Ms. Obama. Let's go. Mr. Marufo, are you there?
Yes, Judge. I was trying to reach out to Mr. Robert Dry. Is that the one that was missing?
Miss Obach is here for him, I believe.
Oh, okay,
Yes, that's correct.
okay. In cause number 2021, DCV 2417, Antonio J. Diaz versus El Paso Healthcare Systems Ltd. et al. Announcement of council, please.
Al Melendez on behalf of Antonio Diaz, Your Honor.
Cynthia Llamas here on behalf of defendant and movant Dr. Crosby.
Gary Norton for Las Palmas Medical Center, Your Honor.
And Michelle Obach for PA Rincon.
All right. So we're scheduled for Ms. Llamas, your motion for summary judgment.
Yes, Your Honor.
Trying to look at recent pleadings. All right, you may proceed.
Yes, Your Honor. At the heart of the medical care is a voluntary and consensual relationship between a physician and a patient that the plaintiff must prove existed between himself and Dr. Crosby in order to be able to proceed with a medical negligence claim. The plaintiff in this case, Mr. Diaz, admits that he had never been Dr. Crosby's patient and that in order for the physician-patient relationship between them to exist, Dr. Crosby had to have taken affirmative steps to treat him. Because the plaintiff didn't do so in response to the no evidence motion for summary judgment, we ask that the court grant the summary judgment on the issue of no duty. Just briefly, Your Honor, Dr. Crosby was the attending emergency medicine physician at the Las Palmas emergency room on November 1st of 2019, when Mr. Rincon presented for care regarding an injured knee. Now, as I said, the plaintiff fully admits that he never saw Dr. Crosby, never spoke with him, was never, there was no personal interaction between the two. All that Dr. Crosby did in this case, Your Honor, at least the only things that have been offered, is that he reviewed Mr. Rincon's diagnosis and disposition when he co-signed the chart after Mr. Diaz had left the emergency department. Further, he also signed an X-ray order, again, well after Mr. Diaz was in the emergency room. In order to be able to proceed with this lawsuit, the plaintiff had to prove that these acts were affirmative acts of medical care to treat him, and he didn't do so. I'm going to rely on my briefing. I provided Your Honor with a courtesy copy of of my motions and the responses, which really sets out what the law is, in more detail as to the duty, the physician-patient relationship, and what needs to be proven. But, and I'm happy to go through those, but I think that Your Honor can rely upon what has been written and what plaintiff has offered as well. As I understand the plaintiff's argument, the plaintiff's response to the no evidence motion, he's offering two arguments. The first is that Dr. Crosby, as the attending physician, had a duty to supervise Mr. Rincon. The second is that because Dr. Crosby reviewed Mr. Rincon's note, signed off on the chart, and signed an X-ray order, or rather co-signed an X-ray order, that therefore that's sufficient evidence. Your Honor, it just simply is not the case. Whether Dr. Crosby was supervising Mr. Rincon had absolutely nothing to do with whether Dr. Crosby and Mr. Diaz had a patient-physician relationship between them. There is no agreement between Dr. Crosby and plaintiff to enter into the relationship. Plaintiff has never alleged also, Your Honor, that Dr. Crosby is vicariously liable for what it is that Mr. Rincon did or didn't do. His claim against Dr. Crosby is for direct liability, for duty to him and him alone. Now, the summary judgment evidence will show that Mr. Rincon saw the plaintiff alone. He didn't ask Dr. Crosby for any assistance. He didn't ask Dr. Crosby to come in and help him review the chart or anything. And Dr. Crosby never took over the care of Mr. Rincon. Dr. Crosby also did not, there's no evidence that Dr. Crosby held out Mr. Rincon as his agent. And Mr. Rincon, importantly, also didn't claim to be Dr. Crosby's agent. There's absolutely no evidence that plaintiff consented to care by Mr. Rincon as an agent of Dr. Crosby. So there's just no meeting of the minds here and nothing from which this court or plaintiff can show that there was a physician-patient relationship between the plaintiff and Dr. Diaz. Now, the plaintiff claims that Dr. Crosby, as the attending physician, had to supervise Mr. Rincon. This claim that he had to supervise Mr. Rincon is an unfounded conclusion. Plaintiff offers absolutely no facts whatsoever that underlie the conclusion that because he was the attending physician, he had a duty to supervise Mr. Rincon. There is absolutely no admissible evidence that Dr. Crosby was Mr. Rincon's supervisor. The only thing that plaintiff has upon which he relies is a heading on a template medical record that identifies Dr. Crosby as a supervising physician. Plaintiff's reliance on this template language is sorely misplaced. The heading alone cannot create a legal relationship between Dr. Crosby and Mr. Rincon that is contrary, by the way, to Mr. Rincon's testimony and is contrary to Texas law. Mr. Rincon specifically and expressly denied that Dr. Crosby was his supervising physician when he was caring for Mr. Diaz. He identified another physician, Dr. Al-Chalabi, as the supervisor. So it goes contrary to testimony. The other thing is actual Texas law. Texas law in the administrative code, excuse me, defines who a supervising physician may be at section 22 of chapter 185, which is attached to to defendant's reply. The relationship between the supervising physician and the supervised PA is also a voluntary and consensual relationship. The supervising physician has to notify the Texas Medical Board of his intent to supervise and agreement to accept responsibility for the PA's actions. The PA also must identify their supervising physician with the Texas Medical Board. Plaintiff has not produced any evidence of such an agreement. And he has not produced any evidence that Dr. Crosby met any of these criteria that the Texas law sets out as to who may be a supervising physician. That heading, Your Honor, on the form alone cannot create a legal relationship in contravention to Texas law. As an example, yesterday I was working on a complaint against a physician who was asked to do an independent medical exam by the Texas Disability Determination Services. It reminded me very much of a case that I've cited in my response, the case of Wilson versus Winnett, that a physician who examines a patient applying for disability at the request of the state has no duty to the patient. In my client's case, he was asked to do a disability determination and to produce a record and a report. He has an EMR that identifies this gentleman as a patient, and that's what he turns into the state. But just because his EMR says patient is not enough to make him a patient of the doctor. As that Wilson v. Winsett case sets out, the examining physician's duty in that case was to the party who contracted him for the exam and the report. There's no duty of that doctor who did the disability exam at the behest of the state to inform the patient of what the findings of his exam were. Incidentally, in that case, there was a patient claimed that the IME doctor had a duty to tell the patient about this lung mass. And the court said no. That patient did not go to that physician for the purposes of seeking treatment. He did not even select the doctor. He did not submit to the exam for purposes of getting diagnosis and treatment from that doctor. So, the fact that a printed copy of a record says someone is patient doesn't make it so. In this case, plaintiff is really relying heavily on the record that says that identifies Dr. Crosby as supervising physician. But again, Your Honor, that heading alone, without anything more, is not enough to create that legal relationship. And as I said earlier, the fact, even if he was Mr. Rincon's supervisor, that has nothing to do with the relationship between Dr. Crosby and the patient, because plaintiff is not alleging a vicarious claim against Dr. Crosby for Mr. Rincon's actions. What's really going on here, Your Honor, is, and if you read the evidence, especially Dr. Gibson's declaration, what plaintiff is trying to do is he's making the case that Dr. Crosby, as the attending physician, was responsible for what transpired in that emergency room because of his position. And that is a captain of the ship argument without using those words. It's black letter law in Texas that a physician's presence does not make a physician responsible for the overall care or the conduct of others within that doctor's purview. The Texas Supreme Court expressly disapproved of these types of arguments in medical negligence cases in the Sparger versus Worley Hospital case in 1977. Also, the claim of supervision is not enough to establish a duty to act. The very case that plaintiff cites in his response, the Reynosa case, Reynosa versus Huff, proves and shows that a case of negligent supervision, a claim of negligent supervision is not enough. In that Reynosa case, the Dr. Huff was supervising residents in an obstetrical surgical unit, and the patient claimed that his presence bound him to assure that she received proper care because he was responsible in supervising the residents that attended to her. The court struck down that argument, saying, as plaintiff in his response does, the doctor had to have taken an affirmative step to treat the patient before the relationship can be established. Now, the review and co-signature of Mr. Rincon's notes don't give rise to this relationship. Plaintiff has not shown that they were voluntary or that they were affirmative acts by Dr. Crosby in an effort to treat Mr. Diaz. The summary judgment evidence simply shows this. Dr. Crosby reviewed and co-signed the chart because his medical director required him to do so. Plaintiff offered absolutely no evidence to the contrary, or that Dr. Crosby had any choice in this matter. This goes against the wholly voluntary nature of the physician-patient relationship. Dr. Crosby, a physician has to be able to accept or decline to enter into such a relationship. Texas does not allow duty to be imposed by a third party alone. Importantly, Your Honor, plaintiff can't answer these questions. He's offered no evidence of what was the purpose for the co-signature of the X-ray order or the note. All we know is that it was signed because the medical director, a third party, required my client to sign the note. Plaintiff offered absolutely no evidence that this act was any part or form of medical care, that it was any part on that there was any intent on Dr. Crosby's part by signing this note to treat Mr. Diaz. And it was his burden to show that these two acts, these co-signatures, were affirmative acts of medical care. The X-ray, both of them were done after the patient left the emergency room. There's no evidence from which he could argue that signing the X-ray order was somehow required to treat Mr. Diaz. Mr. Diaz had the X-ray done well before Dr. Crosby co-signed Mr. Rincon's order for the X-ray. Likewise, Dr. Crosby signed the chart well after Mr. Diaz had left the emergency department. It's plaintiff's burden to show an affirmative act of medical care. He has failed to raise such evidence in the response to the no evidence motion for summary judgment. Therefore, this court has no choice but to grant the no evidence motion. If needed further, Your Honor, I can go on into, I do have objections to the plaintiff's evidence. Plaintiff filed, and I just got notice that he filed something like 30 minutes before this hearing or 45 minutes before this hearing. Plaintiff filed the affidavit of the declaration of a Dr. Gibson. First and foremost, Your Honor, until you find that there is some evidence of duty, none of that other evidence has any bearing on the case. Dr. Gibson's declaration and plaintiff's late filed and subsequent evidence go towards mostly the subjective element of gross negligence, which is required in order to prove a case against the doctor. I will ask for rulings on the objections that until there's a finding of duty, which there has not been, none of this information, none of those additional filings have any relevant admissible evidence. Plaintiff hasn't laid the foundation for them until duty. If Your Honor wishes to entertain arguments about right now at this time about my further objections to the timely and the late filed evidence, I can do so, or I can wait until Mr. Melendez responds, or We can do so at a later time, whatever the judge's preference is. But first and foremost, plaintiff never answered the question, why is Dr. Crosby's signature in this chart? What was the purpose of it? Because he can't answer that question. He hasn't shown that they were affirmative acts of medical care. And without an affirmative act of medical care, Dr. Crosby and Mr. Diaz had no physician-patient relationship, no duty, no cause of action.
All right, let's go ahead and stop right there, Mr. Melendez.
Thank you, Your Honor. As always, Ms. Llamas does a outstanding job in her oral argument and also her briefing. So in this case, Mr. Diaz, just to give some medical history of why he went to the ER, he was with his wife attending a healthcare facility, and the wife fell, and he tried to brace her, and she fell on his leg, and that caused a fracture of his knee. And it was a part of the fracture that what's called a tibial plateau, which is the flat part of the bottom part of the knee. And so he goes to the emergency department with his son and his wife, and he's attended by physician assistant Rincon. So let me stop there and then talk to you about the medical record. So the medical record is obviously, and we all say this, is a legal document. I mean, it has to be accurate, it has to be complete, and most experts that I know of rely heavily on a medical record to create the foundation of duty, liability, standards of care, etc. And so that's what I'm doing. I'm going to rely on the medical record to establish what type of relationship, if any, did Dr. Crosby have with Mr. Diaz. So the going back to the physician-patient relationship and just some legal understanding that I have on it, because Mrs. Llamas and I have crossed paths with respect to physician-patient relationship in the emergency department before. For instance, the fact that he's never seen this patient before is significant. The fact that, in other words, he didn't have an ongoing relationship, so that enters heavily as to what needs to be done in order to create that physician-patient relationship. Well, I think the courts, and I think Ms. Llamas and I agree that there has to be affirmative acts in that regard. Dr. Crosby needs to do something in order to show that he's going to be involved in patient care. And Ms. Llamas is right, there has to be a consensual relationship. I mean, if he has to agree to do something. There was a Supreme Court, the Pope case, that's, as Ms. Llamas has refers to as the Seminole case, where an on-call doctor, he asked an emergency doctor, well, tell me about this case. Tell me a little bit about it. I don't know if I should take it or not. And this ER doctor tells him what to do, and he says, no, I can't take it. Send it to somebody else. And in the Pope case, the Supreme Court says there is no duty. There is no duty. He was just asking the ER doctor for facts in order to determine whether he should even see the patient. And so that created, again, a foundation. Okay, there has to be something more before the physician is considered to be the patient's physician, the physician-patient relationship to be created. Okay. And so going back to this case, let's just look at the medical records first to kind of understand, does the medical records provide evidence that Dr. Crosby took some sort of affirmative act to have a relationship with Mr. Diaz? I have, if I can share my screen, maybe that would help just to kind of go over some of the.
You may. If the function is, I'm not sure what the default is. There you go.
So this is the medical record, and of course, Ms. Yamas and I think we rely heavily on it just to kind of be able to understand the facts. And the medical record, as you know, Judge, it's supposed to create a story of what happened. Why did the patient go to the emergency department? What was his complaints? What did the doctor or any healthcare who touched this patient do in relation to that care, to the diagnosis or treatment, the furtherment of those services? And so when we go here, we know right away, without having to annotate it, Dr. Crosby is the attending physician. Now, the attending physician, as you know, Judge, creates a special relationship. The attending physician is in charge of the overall care of the patient while the patient is in the facility, in the emergency department in this case. And we already know.
I'm sorry, but I must object because there's absolutely no evidence in the medical record or in the summary judgment evidence of that alleged duty of the attending physician. There's been no testimony whatsoever of what is an attending physician. What is an attending physician's responsibility? What role and scope does that position have? This is simply argument, mere conjecture.
Thank you, Ms. Llamas. I'll note your objection. Go ahead, Mr. Melendez.
And the term attending physician, Judge, you just have to go to the dictionary and look it up. It's not a secret. It doesn't require expert testimony to know what an attending physician his responsibility is. Now, that's significant in this case. And the reason it's significant because the attending physician is responsible, as I said, for the overall care. And when you look at the medical record, this is consistent with what I just said. It's consistent because throughout the medical record, his name continues on, and I'll show you as we scroll down, but I want to get to the next, just for purposes of timeline. We see here that right here, I don't know, you probably can't see it, Your Honor, and I don't want to.
I'm not sure what you're pointing to, but I can see this document very clearly. So tell me what you're asking me to look at.
There's a right here. It says 8/1/19 time 11:30. Can you see that one, or should I try to mark it up?
I can see it. I can see it.
And then discharge 13:02, and I have a 1:02. At least that's what this record shows. So it's an hour and a half. Okay, the next document we're going to see is what's called emergency provider report. And it's date and time, as you can see, 11:41. And you can see the author here, Jose L. Rincon, PA. So he's the author of this document. Now, this document, if we scroll through it, it says page 1 of 6. And this reflects the care that Mr. Rincon provided to Mr. Diaz. And you see here, there's a time here, 11:41. And he talks about HPI, the history of present illness. There's a knee problem. And he gives that history that we just talked about. Patient states his wife fell on his legs, and there's some probably misspelling in hyperextension of the knee. And there's some documentation about his symptoms. And then when we scroll down, obviously it says free text ROS, which is just review of system notes. There's various notes within here, and they're just documentation of what should be Mr. Rincon's evaluation. And then they talk about the past medical history. They talk about home meds. As you can see, these are categories of information that obviously when it's documented, there should be something there relating to that, or at least if there's nothing there, then we can assume that it's either not significant or was not addressed. And then I'm going to scroll down here, vital signs. And it looks like the last vital sign, first vital sign was 1132. And then the last vital sign was 1301, if I'm not mistaken, unless there's another one down here. No. And then we have something that's called free text PE notes, which is just the physical examination notes. And then significant to this fractured knee, there's the exam of the extremities, which is the left knee with tenderness, swelling, limited range of motion, anterior and posterior draw test negative. That at least here there's a reference to certain tests that PA Rincon applied. They talk about the neurovascular is intact, and then distal to the area of concern. That means obviously that it's just that there's no vascular or blood vessel injury that he noticed. The rest of the extremities appear atraumatic, which, there's no trauma, non-tender. So he doesn't see anything here except for the left knee with tenderness, swelling, and limited range of motion. And then here we have interpretation and diagnostics, lab results, interpretation. And then here we have something interesting. It says there's recent impressions. It says radiology, x-ray of the left knee, 3 views. And it says here 1145. And then we have here report impression, status, signed and entered 1322. Now I'm going to jump ahead just so we can have a reference of what that means. When this report was entered here at this point at 1322, Mr. Diaz had already been discharged from the hospital with a knee sprain. And just to jump a little bit ahead on looking at the x-ray and the timetable here. Just here, we see this here, 1145, report impression, sign, entered 1322. Let me see if I flagged this correctly. I don't think I did, I'm sorry. Let me back up again. And then let me just scroll. This is for, let me just scroll to the x-ray report. There's an x-ray report here, Judge.
Mm-hmm.
And this was, I think the evidence will show, if it hasn't already been established, that this x-ray was performed and it was sent off to a teleradiologist, Dr. Takaguchi. I hope I pronounced that correctly. And then he diagnoses hemarthrosis. It's just blood, Judge, in the knee. And then impaction fraction of the lateral tibial plateau. There's a horizontal fracture extending into the proximal tibial metaphysis and diaphysis. It just means he has a fracture on the top of his knee, Judge. And the top means the bottom portion of the leg, which extends into the knee. And then he signs it here at 1316. Okay. And then again, just for reference, says copy to Mark Crosby. So why is Dr. Crosby part of this medical record? And why is he copying Dr. Crosby of these findings? If we look here, I just want to identify here, 1316 again, that's when he signs it. If we go back to the PA's note. Let me make sure I can get to the note. (1316). Well, this is 1322. About 6 minutes after he signs the report that I just showed you, it's entered here at 1322. Says signed and entered 1322, and it gives the same impression again. Copy and paste right here. And then importantly, just to kind of continue this storybook as shown in the medical record, the imaging statement. Radiographic studies reviewed and considered in the medical decision. Of course, that's 3101. I don't know if you need a doctor to tell you that if you order an x-ray, you should find out what the results of there are. If you order any test, the ordering physician should find out what the results are. Now, going back to this order, who ordered the test and how was that? As you know, Judge, everything has to, when nurses can provide certain care, but they can't order an x-ray. That has to be done by a healthcare provider. In this case, again, they reference Crosby, Dr. Crosby here on this order sheet. And then I try to make it big. It says here 1141. And just to get some perspective, Judge, here at time 11:45. Left knee 3 x-rays, order. I'm assuming that's Rincon. And it's left knee 3 views. And then as you scroll down here.
Let me ask, as we're going through, I guess, kind of piecemeal here, up there on that line where it starts rad left knee 3 views, it says over here ordered by C. Roma. Is there anything indicating who that is or what that is?
That part I don't know, Your Honor.
Okay, go ahead.
The one that I'll have to ask Mr. Norton. He's a master at understanding these, but I'll have to get back with you on that. But I don't know off the top of my head.
Well, let me see. If I go through that orders audit trail of events, it looks like signed by Mark Crosby and it says MDC Roma there. So is that Mark Crosby? Is that?
Your Honor, I believe that the summary judgment evidence does not show what that is, and it is improper for Mr. Melendez to give you that testimony. And I have further arguments, but I'll wait until he's done.
Go ahead.
And then says here electronically signed by Crosby Mark at 1514. So if we look at this, I mean, he's electronically signing it. I'm assuming that he's signing it because there's nothing in here that indicating that he's not signing it. Again, we're here at a summary judgment hearing to find out, is there any evidence associated with, or what evidence is associated with Mark Crosby's care and treatment and diagnosis of Mr. Diaz. And so this.
Mr. Melendez, let me just stop you very quickly. Is Ms. Obach frozen, Mr. Mandulfo, or what's the issue? It's hard for me to see.
She keeps kicking out of the meeting and she'll log back in and then she kicks out. I don't know. I don't think she's there right now.
Let her know that if it's a computer issue, she can call in by phone right, and hear it on her phone, not video, right? There's an alternative number.
Okay, Judge, will do.
Your Honor, she's been emailing me and I've been chatting with Mr. Marutho to let her know that she got kicked out.
Oh.
But she's not mentioned being kicked out yet again. But I will represent that this motion is only between
Right.
and Mr. Melendez as well.
Right. Please contact her via telephone, because if it's like a computer breakup issue, sometimes just using the dial-up number will take care of that. Okay.
Yes,
And
ma'am.
thank you very much. All right, I'm sorry, Mr. Melendez, go ahead.
That's okay. That's important that see if all counsel are available to hear this. And so we were just talking about the signature of Dr. Crosby here.
Mhm.
And then we already talked about him being CC'd on the X-ray report. And then him as the attending physician. Okay, and then let's go back to the PA's note.
Ms. Obach, are you connected? Okay, I see you talking, so as long as you can hear us, that's good. All right, thank you. Go ahead, Mr. Melendez.
So at the end of the we're here, let's see, on page 4 of 6. We're almost finished, Judge, at least for the record. Clinical impression, primary impression, left knee sprain, secondary expression, left knee injury, disposition, decision, discharge home. There's a date and time here, 1919, 1801, and 19. And this is the part that talks about Dr. Crosby and whether or not there's a physician-patient relationship. And it's dated A2 of 19 and 2339, which implies that this is the time that he's documenting in the record. And again, I'm not sure we have to go beyond the fact that if he signed it and it's documented, we can assume that he created it. And here there's a reference to initial read date and time, 1132. I don't know what that means. And then there's a patient discharge and departure. And then underneath that is called supervising physician note. And underneath that, he documents mid-level, which is PA Rincon, saw patient alone. And I'm taking him at his word that he never saw Mr. Rincon, I'm sorry, Mr. Diaz, based on this note. And it says, I have reviewed the PA NP's note and plan of care. I was available for consultation as needed at all time during the patient's visit in the emergency department. And then I agree with the clinical impression. I agree. Of course, I'm paraphrasing just to emphasize. I agree with the plan. And I agree with the disposition. And this is signed, electronically signed by Dr. Crosby on A2 at 2345. And then going back just to keep it in perspective, Mr. Diaz was at the hospital at about 11:30 or so in the morning on the day before on 8/1. And he signs this note at this time. But this is the affirmative act that I understand there's a dispute. The dispute is this enough to create an affirmative act that Mr. that Mark Crosby is involved in is there a physician-patient relationship because he has agreed, he has consented to become involved in this physician-patient relationship. He is consented to be involved in some form and fashion of this diagnosis, the assessment, diagnosis, and treatment plan. And in my opinion, when I see somebody signing this note, he's agreed to that. He's consented to be involved in this physician-patient relationship. Now, I know that's the dispute. The dispute is just because he signs this note, this doesn't necessarily create an evidence. I understand. But what we're here to find out, is there a scintilla of evidence that this, in fact, does show consent? Is there a scintilla of evidence that this does show that he's agreed to be involved in the care provided to Mr. Diaz? Oops. Okay, so we have at least some, what evidence do we have, just to kind of go in my own head? He's the attending physician. He signed off on the x-ray note, so he knows there's a note. And now he signed off as the supervising physician note. And he signed off that he's reviewed the PA's note and plan of care. Now, I understand he may say, look, I didn't review anything. Well, that's a question of fact. It's just a question. Or I just reviewed the fact that he had a sprained knee. I didn't even look at anything else. Well, that's still a question of fact. Because I have 6 pages of Mr. Rincon's notes, 6 pages of his notes. And then I agree with the clinical impression, plan, and disposition. Well, he may say, look, my clinical plan and impression, all I wanted to know is, what was the diagnosis? Sprained knee. And what did you do? Send him home. Well, that's fine, but there's still evidence here that he did more than that when he signed off on this note. There's no restriction other than to say, I reviewed the note, and it just doesn't fit. It's not consistent, especially he's given a copy of the x-ray. He has to sign off on the order, which he does. It doesn't have to. He could have refused. He could have refused to be part of this care of Mr. Diaz, but he didn't. He signed off on it. He did this voluntarily, consensually, and that's the relationship. Now, in response to I think, and this is, as you get older, my memory is not, but I thought there was some reference to, there's no billing or anything to show that Mr. Diaz and Mr. Dr. Crosby had anything to do with each other. And so I found this morning that there was billing statement that Mr. Diaz had provided me, and I shared that in a response to production, and I just filed it this morning, and I apologize because it's something that's it's just ongoing. And so I attached it as a reply to Miss Dr. Crosby's reply. And so I'm looking at this, and here's the note, here's the bill that Mr. Diaz provided. I don't know if, let me make it bigger. It says Jose Rincon, emergency visit / Mark Isaac Crosby, $549. Okay, so there is a lot of evidence, and just in my head, that maybe there's not, but that there is a physician-patient relationship between Dr. Crosby and Mr. Diaz. So I can't think if there's anything that I missed. I just touched base briefly on the concept that Dr. Diaz didn't do this voluntarily. Well, I think we talked about that. That he was forced to somehow because that's what he's required to do.
You
Well,
mean Dr. Crosby? Yes.
Judge, I have I created a brain trace or of Dr. I keep on referring to Mr. Diaz as Dr. Diaz and Mr. Crosby. I apologize. So as Dr. Crosby, yes, ma'am. And so and the part that Ms. Llamas talks about that he is not the supervising physician but I understand if you're a PA, the administrative code requires that you have to have a supervising physician. And that's the overall, that's part of the administrative requirements. If you have our PA or NP, you have to have a supervising physician sign off on you. But that has nothing to do with the role and responsibility of Dr. Crosby as the attending physician in the ER on 8/1/2019, Your Honor. He can still be a supervising physician for the care provided to Mr. Diaz, and there's nothing inconsistent with that. And then I'm trying to think if there was anything else that was referenced, but that's it, Your Honor. That's the gist of my argument at this time.
Okay. All right, Ms. Llamas, go ahead.
Yes, if I may respond. Apologies.
Yes, Mr. Melendez, will you stop sharing your screen?
Oh, yes, ma'am.
Thank you. Go ahead.
You know, the role of an attending physician, again, I'm going to object. It's sheer speculation on Mr. Melendez's part that the role of the attending physician requires him to be in charge of everything in the ER. And it's just a restatement of that captain of the ship doctrine, which is absolutely impermissible in Texas. I wanted to point out something really interesting. Mr. Melendez's argument, to Your Honor, said, why is Dr. Crosby a part of his record? Why does the radiologist copy him? Indeed, why? It was Mr. Melendez's burden to prove a reason for why Dr. Crosby's name is even in the chart, and he didn't do so. He cannot answer that question. Without answering that question, there's no physician-patient relationship. The case, Your Honor, is built on inference upon inference upon inference. You cannot raise a scintilla of evidence sufficient to overcome a no evidence motion for summary judgment on stacking inferences. That's black letter law in Texas. It's set out in my objections to Dr. Gibson's declaration and the late filed evidence. This is a case built on sand castles. There's no solid foundation for Mr. Melendez to make these inferences. To make the inferences that he does, well, okay, Dr. Crosby was copied on the x-ray report. That shows there's a physician-patient relationship. No, it doesn't, because he doesn't say why. He doesn't show you why he's copied. Not to mention the fact, Your Honor, that the fact that Dr. Crosby was copied on an x-ray report, when? How? Mr. Melendez offers no evidence that Dr. Crosby was copied on that x-ray report at any time pertinent to the case at issue. If you look at the actual evidence that was filed, and I believe it's in one of my responses, Mr. Melendez just puts forth the evidence that, oh, he was copied on a report. And Dr. Crosby actually will tell his testimony, which Mr. Melendez filed, does say how he is copied on reports. He's not copied on paper. He's told electronically that there's a record in the chart, but that's only when the patients are on a tracking system. And Dr. Crosby testified, I don't know if I'm getting too in the weeds here, but as it pertains to this case and it pertains to the inferences that Mr. Melendez needs to be true in order for them to be some evidence of negligence, Dr. Crosby had to be aware of this x-ray report when he reviewed the chart, and he testified that when he reviewed the chart, this patient was no longer on a tracker. There would be no tracker to tell him that there's an x-ray report on file. And that's the only evidence of how he gets an x-ray report. But really getting down to the case. Dr. Crosby's agreement with Mr. Rincon's documentation is not evidence that he participated in the care of Mr. of Mr. Diaz, absent proof that these were affirmative acts of medical care. How is this intended to diagnose, treat, try to evaluate or diagnose or treat Mr. Diaz? There's an absence of evidence of the purpose behind these signatures, whether it's a hospital requirement, whether it's a, internal requirement, something that the hospital does. That alone is not going to give rise to a duty by Dr. Crosby to Mr. Diaz, a person whom he never saw and of whom he was unaware the entire time that he was in the emergency department. This would be a completely different case if, for example, Mr. Rincon had asked for Dr. Crosby's assistance and Dr. Crosby had offered some affirmative care, said, okay, no, I agree, let me see, let me help you out. What's going on with this x-ray? That's not the case here. The case is that Dr. Crosby's only connection to this case is signatures done after the fact. I would also like to point out that there are, maybe for the interest of expediency, but in order, Mr. Melendez fails to put forth and point out the evidence that contradicts his entire argument, and in raising a scintilla of evidence sufficient to overcome a summary judgment, you cannot ignore contrary evidence. Mr. Melendez's arguments at most raise a mere suspicion. They do not rise above conjecture, especially in light of the contrary evidence that this court cannot ignore. And again, that note, calling him a supervising physician, doesn't make it so. Texas law cannot be abrogated by a template on a medical record. Just quickly, Your Honor, I don't know if it's important, but I would like to point out, and if you need to see it, I can put it up on my screen, to the extent that Mr. Melendez is claiming, oh, well, Dr. Crosby ordered this x-ray. I don't know if he showed you all of the documentation of that x-ray order. It's under Mr. Rincon's signature, and I can put this into the record, but at volume 2, page 28 of Mr. Rincon's deposition, which conveniently Mr. Melendez did not put in the record, Mr. Rincon says he is the one who ordered that x-ray. Furthermore, Mr. Melendez's expert, Dr. Gibson, admits in his declaration that the order was by Mr. Rincon. So to the extent that there is an insinuation that that document, that page that Mr. Melendez showed you is proof that Dr. Crosby ordered that x-ray, that is flatly contradicted by what the evidence has actually been in this case and by his own expert. It was Mr. Rincon who ordered the x-ray. Finally, in terms of that billing record, again, Your Honor, this is inference upon inference upon inference. What does it mean that Dr. Crosby's initials are after Mr. Rincon's initials in that billing record? I don't know. Mr. Melendez can't tell you. There's no evidence here. And by the way, that was filed late, and there is no motion for leave to file that additional proof that shows that it wasn't due to due to accident or mistake. In summary, Your Honor, and if Your Honor wishes to take up arguments on the formal objections to the plaintiff's proof, I can do so now, or we can do so later. I've provided Your Honor with full arguments, proposed orders. The bottom line is the proof that Mr. Melendez has is, again, sandcastles. It's inference upon inference upon inference. If you just look at page 6 of Dr. Gibson's declaration, you can see the proof of the pudding is there. He essentially tells you, I am making all of these inferences one upon the other. And Dr. Gibson's affidavit and declaration is entirely unreliable. Mr. Melendez says, I'm going to rely upon medical records because that is what reasonable people do in order to form the bases of their opinions. Well, garbage in, garbage out. You can't omit evidence that is conveniently contrary to your case just to get a favorable opinion out of an expert. In order for that expert to have a viable, credible, reliable foundation, one that will meet Dalbert and Robinson standards for admission, you've got to provide that expert with all of the evidence. And conveniently omitting all the testimony that contradicts your theory of the case, that's not reliable. That's not admissible evidence. If Your Honor wants to take up additional arguments on the objections, I can do so at this time. Otherwise, I will respectfully request that Your Honor grant the objections to the extent they are necessary to be granted. Find that there's no credible, admissible scintilla of evidence of a duty and a physician-patient relationship between Dr. Crosby and Mr. Diaz, and for a grant of the summary judgment. I will, on the record, Your Honor, withdraw my initial objection to plaintiff's late filed evidence. The response that Mr. Melendez filed last night points out that his was a mistake, an accident, and I take Mr. Melendez at his word. So I will withdraw that particular objection, but not my objection to this morning's filed evidence.
All right, understood. Understood. All right. Well, I feel comfortable with everything you all have presented today, and need to review actually quite a bit more. Mr. Melendez, in terms of your motions, and I was trying to go through several of these. I think I have a good handle on the declaration of Dr. Gibson. I want to make sure I understand what you're asking in terms of your motions, because I think there's two motions for leave to file late evidence. I have not fully reviewed those on Odyssey. So tell me what goes where.
See, so what I did, Your Honor, is that when I for the first supplemental, and I filed that on the 4th, I think.
Yes, January 4th.
There was a motion to file the late supplemental, and then I went ahead and that's the one that Ms. Llamas says that it's okay. And thank you, Ms. Llamas, to go ahead and do that. I had to file and then I filed a first supplemental motion to my original motion for leave, which just identifies my mistake and not my conscious indifference for filing it late. I had prepared it on the 3rd, ready to file it, and then I just spaced it. And I was gonna let you know, Judge, and I keep on doing this. I don't know why. I said it, I think, during deposition, and it became a solid memory trace that I default on. In my response to summary judgment, I say, so what did Dr. Diaz do wrong, or how did he breach the standard of care? And I apologize. It's supposed to be Dr. Crosby, and I think I did that in one paragraph, maybe more than one paragraph. I referenced Dr. Diaz. There is no Dr. Diaz. It's Dr. Crosby.
All right, if you all have nothing further, I'm going to go ahead and take this under consideration. I don't want to tell you a week, because realistically it might be 2. So anticipate about 2 weeks. I see yes, Mr. Norton?
The only other thing I want to add, Judge, I was looking at the docket there. It shows a 3 p.m. hearing in this case for entry of a scheduling order. However, we entered one back in December, so I just wanted to make sure that we weren't expected back.
I don't see it.
It was attached to the one that Mr. Marufo sent out to me.
Apologies, Your Honor. I did have my staff call the court to make sure that the court was aware we had entered into the DCO, and it was removed from the calendar, and I assumed that it was communicated to all counsel. I apologize. I got that hearing this afternoon canceled, everybody.
Yeah, okay. That's all. It was just on the docket that was attached to the email providing those Zoom links. So I wanted to make sure that, because I wasn't planning on coming back.
We're good to go. Thank you for being thorough. Thank you all for your arguments today, and I anticipate about a 2-week turnaround on this one. Do we need something before? No, I'm not even going to say that. I assume we are going to have a hearing before then, and some shape, or form, and I rely on you all. Thank you very much for your efforts. Is there anything else?
Your
No, Your
Honor, I think we have a trial date in June or July. I can't remember. So we're okay.
Oh, we're in October, Mr. Melendez.
October.
In
Oh,
fact,
October,
you
my
all-
goodness.
You all
So we
don't
have a
come
lot of time.
back until August,
We could,
officially,
there-
as of right
and-
now.
and and just, I think we talked about this, Your Honor, just in case it's not a big deal. Maybe during this time, you never know, we may get the Court of Appeals has the same type of ruling pending on a different case. So that's it. That would be interesting if we were to get that ruling before.
All righty. Thank you for the heads up, Mr. Melendez. We'll talk to you all soon.
Thank you, Your Honor.
Thank you. Judge.
Thank
Thank
you.
you,
Have
Your
a good
Honor.
day.
May we be
All right.
excused?
You may. Have a good day.
Thank you,
Trying to
Cynthia. Good
see
job,
who's
Cynthia.
left.
You will.
How about we take care of Mr. Duke? Is that on? Are you covering Mr. Duke for Ms. Labinati?
Well, I'm lead counsel for the, if it pleases the court, I'm lead counsel for the plaintiff. So I'm here for Ms. Alcantar.
Top of page 5, Judge.
Oh, okay. My apologies. I hadn't gone through. All righty. Let's start there.
In cause number 2023 DCV 1828, Emma Alcantar versus Alejandro de la Cruz et al. Announcement of counsel, please.
And again, good morning, Judge Brett Duke on behalf of the plaintiff, Emma Alcantar.
Your Honor, good morning. Blake Downey on behalf of defendant Alejandro de la Cruz.
Morning, Your Honor. Alejandra Rodriguez on behalf of the defendant, Canupio Independent School District.
All right, let's see. We're set for special exceptions. Why do I feel I received something recently on this?
Your Honor.
Oh, I see. Go ahead.
I know the answer to that because yesterday I hand delivered a paper copy of the response to you.
Got it. Okay.
I haven't received a copy of that response, Your Honor.
Looks like it was filed January 8th.
Yes, Judge, it was filed January 8th and served electronically on January 8th.
Okay. Hold on a second. Odyssey just decides when it wants to work and when it doesn't.
I do see it, Your Honor. It was the same day that a proposed order came in for the scheduling order. That's fine. I'm still ready to proceed with my argument.
Okay, here it is. All righty. Sorry, things just load up a little bit slowly on Odyssey. Mr. Downey, you may proceed.
Thank you, Your Honor. I've lost you guys. Let me see if I can find you all in my Zoom. There we go. Your Honor, it's a fairly straightforward special exceptions. Your Honor, we have a case where plaintiff has accused my client, who is a coach and teacher at Canutillo High School, of sexual harassment to include physical assault. The pleading standard in Texas, we're all very well aware, it's simply notice pleading. However, there has been no evidence and there's no facts that are pled that describe any type of physical touching or physical assault, or any type of knowing or reckless touching or imminent touching, such that we can understand what the theory of the case is. So I would ask the court to instruct Mr. Duke to simply plead what minor facts there may exist related to an alleged physical assault. They certainly have pled with specificity, believe it or not, for sexual harassment and different types of behavior, but do not do so for assault. So we would ask that they plead and do so. We are in the discovery process. I understand that I have the ability to do discovery, but that has also been somewhat fruitless at this point. So we would simply ask for a very, very simple couple sentence replead about what they allege this assault is that occurred.
Thank you, Mr. Downey. Mr. Duke?
Judge, I ask that you overrule defendant's special exception Rule 45 tells us what the pleading standard is in the state of Texas, and it states a pleading shall consist of a statement in plain and concise language of the plaintiff's cause of action, that any allegation be evidentiary or a legal conclusion shall not be grounds for an objection when fair notice to the opponent is given. In my response, I further provide with authority from the Texas Supreme Court, where the Texas Supreme Court says in a pleading, evidence does not need to be pled, details are not required. Our rules do not require pleadings to contain evidence of factual detail. Now, the special exception is not proper based upon the pleading standards. So we couple the fact that what's required is simply providing notification of the defendant of what our cause of action is. Plaintiff's petition is pretty clear about that. There's an entire count of assault. Paragraph 24 states plaintiff was sexually assaulted at work. Plaintiff was assaulted at work. This assault is separate and distinct. As specified or as specifically detailed above, defendant Dela Cruz assaulted plaintiff. Plaintiff proceeds to plead the elements of the assault claim within the paragraph. In the response, I point to the various paragraphs that contain factual detail of the assault that forms part of the assault claim. So just by making a cursory glance at this petition, it's evident that plaintiff includes in a plain and simple statement of her cause of action of assault against the individual defendant. Well, after the plaintiff filed her lawsuit, the defendant filed an answer. And as I point out in the response, in several paragraphs, defendant admits and recognizes that he is being sued for assault. The defendant states specifically he did not assault the plaintiff. There was no evidence, or there's no pleadings of intentionally, knowingly, or recklessly causing bodily injury to plaintiff. And I don't want to just keep reading the response, especially if you've looked at it, but we see 8 judicial admissions in the answer recognizing that he is being accused of assault. Then subsequently, after the answer is when the special exception was filed, and then a few months later, the defendant files his discovery, his initial disclosures. And in his initial disclosures, he repeatedly alleges that he did not assault the plaintiff. He did not intentionally, knowingly, or recklessly cause bodily injury to the plaintiff. He did not intentionally, knowingly, or recklessly threaten plaintiff. Plaintiff cannot establish the elements of assault. Defendant acted without intent to assault. So defendant is fully aware of the assault claim being alleged against him as he's admitted in his answer, his motion for special exceptions, and his discovery responses. So it's fairly outrageous that we're here right now. Defendant is saying, I don't understand the assault claim against me, so please make him say that there's an assault claim. So the rules do not require specificity or more detail. I think the petition satisfies the rules clearly. I think there's information in the facts section. So for that reason, I do ask you to overrule defendant's special exception and deny it.
Mr. Downey, do you have anything else? You're muted.
It's a very quick response by way of what Mr. Duke is saying is basically I'm handcuffed for being able to answer a lawsuit, which is all we've done in the case. We have to be able to understand the facts, and because he says plaintiff was assaulted, please see herein plaintiff was assaulted. We have no idea what he's talking about. I mean, if you look at his facts section in his case, he's clearly with dates and other describes different types of harassment that she alleges occurred, But then out of nowhere, we have a physical touching and a physical assault of some kind with absolutely no idea of what's being addressed. And like I said, Your Honor, if the court is inclined to deny, we can certainly take it up in discovery, and that's fine. But simply just putting out there the word assault and somebody was physically touched inappropriately in a pleading is reckless and dangerous. And frankly, we would ask that he simply replead, to give me fair notice of what the allegations are against my client. Thank you, Your Honor.
Thank you very much, Mr. Downey. Mr. Duke, respectfully, I'm going to deny your request. And sure, we have some time. It looks like jury trial's down in November. I don't have you set again until the final judges conference in August. And so, Mr. Duke, I haven't gone through any recent, meaning like yesterday and today emails. So if you have the proposed order, please forward that to Ms. Hernandez and we'll sign off. We need to come back on something else, please, as you file your pleadings, make your request for hearing and we'll take care of those, okay?
All right.
Thank you for your time. Thank you. I want to go back to Mr. Flores because I thought I did see Miss Yarbrough come back on. Miss Savage, I believe that's you. And frankly, because we were waiting and in so many hearings, Miss Yarbrough, are you still there?
She's not, Judge.
Okay.
I called her and she said she's unable to connect.
All right. So Mr. Flores, yes.
I also spoke to her and notified her about the dismissal hearing in 2 weeks in person.
I think that was all happening at the same time. When I saw her pop on, I think Myrna had just chatted you about just scheduling that motion to dismiss in person. We tend to have too many issues, Mr. Flores, when we try and do this on Zoom. So your hearing will be set, however Myrna got it done, and we'll get notice to Ms. Yarbrough, okay?
Thank you, Your Honor.
Thank you. I'm sorry for the wait. We had a few extra
Okay, I
meetings.
learned a lot. Thanks.
All right. Okay. And so, okay, yeah, now I'm just seeing yours. Who do we have? I want to get to Mr. Lopez and Mr. Salum, and I want to know if Mr. Salum's client appeared.
Yes, Judge. The one that's left is on the bottom of page 4, Judge.
No, but I'm asking about Mary Gonzalez.
I don't see no Ms. Gonzalez. I just see Mr. Lopez's client, Judge.
Okay, let's take care of that one first, please.
Let me bring his client, Judge. In cause number 2022 DCV 3622, Mary Gonzalez versus Covencio Pacheco et al. Announcement of counsel, please.
Good morning, Your Honor. Nasim Saloom on behalf of Mary Gonzalez.
Enrique Lopez on behalf of the Pachecos, Your Honor, defendants.
Okay. Who were we waiting on? Oh, Mr. Pacheco?
Mr. Pacheco is on Zoom, Your Honor.
Okay. My question was, I understand we have the motion to compel and the motion to withdraw.
Yes, Your Honor. The motion to compel is brought by the defendants, Mr. and Mrs. Pacheco. This is the
I understand, but I know we had the motion to withdraw pending last time. And part of my issue was whether she was, I thought I had asked for her to appear today.
Your Honor, you asked me to provide to Ms. Hernandez, Ms. Gonzalez's contact information, which I did, and Ms. Hernandez emailed Ms. Gonzalez. I'm not sure if she called, and I'm not sure if she received a response, but you're correct in that assertion, Your Honor.
So we haven't had any contact from Ms. Gonzalez, is that correct?
Not from the court, Judge. The email went out and the regular mail was sent out, not certified, but regular mail.
In terms of the setting, let me get actually into this case, 3620. In terms of the setting, when it was e-filed, did it only go to Mr. Salum or did it also go to the contact for Ms. Gonzalez? Well, we looked that up, and that's just for my purposes on the motion to withdraw, Mr. Lopez. I have a notation here, proposed order to be filed on the motion to compel.
Yes, Your Honor. I have a proposed order. However, since we had another setting, I defer sending it until maybe there was something the court needed to know. But I do have a proposed order that I can email to the court immediately.
And is it current, is my recollection accurate that it was solely because of the amount that was, I think, continuing to add up, that we did not have a proper order at the previous hearing?
No, Your Honor. Part of it is correct. I think what we were seeking is because she has not made payments, and I amended my order, but she continues not to make any payments in complete disregard to your July 26th order. Right now, she owes $31,500, Your Honor. And I don't think any of that money has been deposited. 31,500 represents 21 months of non-payment of rent. And so my motion was requesting that she deposits that money immediately. And also, Your Honor, if she fails, or maybe we need an order that she needs to vacate the premises, she can continue fighting the case from the outside. And that my clients take possession of the premises immediately or on or before a certain date.
Are all of those requests in your motion to compel?
Yes, Your Honor. My requests are for her to deposit the amounts, the 31,500, pay attorney's fees, which is now $2,000. I think that's more than reasonable. And also for the plaintiff to vacate the premises immediately.
All right. Mr. Saloom, so I'm taking these kind of together, but frankly, let me see, did we get any notice to Ms. Gonzalez regarding with respect to the actual order setting hearing? Was that e-served on Ms. Gonzalez?
Your Honor, if I could just check, to be honest with you, I'm not sure.
It may have come from the court. I don't know that I specifically asked for that because I think we were relying on notice solely from the court and maybe from you, Mr. Saloom, but she's not here. That's my concern.
Correct.
In terms of the motion to withdraw at this point, that was also set today. That is granted. That is granted.
Okay, thank you. I will provide a proposed order for the court to sign.
Thank you very much. Mr. Lopez, your request is also granted if you have that proposed order. That includes the updated amount of funds for past lease amounts or rental payments. The last amended motion I see says 32,250, and today you're telling me 31,500. Is that right?
Yes, Your Honor. What I did is that included attorney's fees, so I broke it down. So the order is 31,500, then now 2,000 in attorney's fees, and then the other relief for her to vacate the premises and also for my client to take immediate possession. The order is on its way, Your Honor. It's being emailed as we speak.
Then I will review the order.
I've just sent you the email that we forward to Ms. Mary Gonzalez with the information that was provided by Mr. Saloom, notifying her of the hearing.
Okay. Okay, so we have an email notice with the actual hearing setting, and we've received no information from Ms. Gonzalez. All right. For my purposes, we're good to go pending review, Mr. Lopez, of your order.
Yes, Your Honor. I left some blanks for the court to fill in certain dates, like for her to vacate the premises on or before January blank, for the court to fill in.
Understood. Okay, Mr. Saloom.
For possession of the property.
I'm seeing an order to vacate. I'm looking at the November. Well, here's the thing, Mr. Saloom, you're out.
Yes, ma'am.
So.
Yes, I understand. I mean, it's just I haven't made contact with Ms. Gonzalez, and I'm gonna have to inform her. I'd like to, put together a final disengagement letter informing her of everything that's transpired, Your Honor.
So in terms of the defendant's amended motion, right, filed on November 13th, request that this court issue an order compelling the plaintiff to deposit the complete funds of $32,250 to pay reasonable costs and attorney's fees and to order plaintiff to vacate the premises immediately. I did not see, and so Mr. Lopez, just know if you're sending me an order with respect to attorney's fees, those need to be proved up. So I'm not really looking at that right now. What I am looking at though, however, is the funds required to be paid for her being on those premises, and then the order to vacate.
Very well, Your Honor.
All right.
If the court, since it's already been sent, maybe the court just scratch that out regarding the attorney's fees.
Did you send me a Word document or a PDF?
We'd normally send a PDF, but we can do, I can send you a Word as well.
Go ahead and send me a Word document. Thank you
Very
very
well.
much.
Thank you.
All right, Mr. Saloom, I hear what you're telling me, but I mean, some of those details, this was a motion to withdraw. I thought we had heard it at a previous hearing, which is why we were sending separate notice to Ms. Gonzalez, anticipating your withdrawal. So.
Yes, Your Honor. Yes, Your Honor.
Yeah, I mean, you haven't had any contact with her, right?
Unfortunately not, Your Honor.
Have you attempted to contact her?
Yes, ma'am.
Okay.
Via phone calls, and I have.
I mean, has anybody gone to the premises and attempted to make contact with her? Mr. Saloom, or, I mean, not that you'd have to, but I mean, things can happen and sometimes people, but I'm assuming she's still operating out of that business location, right?
I can't say definitively, Your Honor.
Understood.
It is a commercial property. It's not, residence or anything, but no, I have not, Your Honor.
Okay. So please send me the orders.
Yes, Your Honor.
Our next hearing is on February 21st. I don't know. Well, nobody's had any updates. So it's not like we have updated information. What I would ask Mr. Medina and Ms. Hernandez is that we square away now that Mr. Saloom has withdrawn, that e-filing contacts include Ms. Gonzalez personally. Okay? Thank you.
May I be excused?
Yes, sir. Thank you. Thank you, Mr. Lopez.
Thank you, Your
Who's
Honor.
left?
Bottom of page 4, Judge. In cause number 2019 DCV 3332 on deck Capital Inc. versus Gerardo Perez et al. Announcement of counsel, please.
Tania Olet for the plaintiff on deck.
And I understand, Ms. Fisher, you're here, and I recall this scenario, the situation. Let me
Yes, Your Honor.
ask Ms. Oh, I'm just gonna say Tanya. Tanya, I'm gonna ask you.
It's very simple.
If have we had some clarity here on this case?
Your Honor, if I may interject just briefly, my client Gerardo Perez Sr. Should be, I don't know if he's still on. He wanted to be able to view the hearing. So with that, please continue.
All right, Miss.
Okay. It's Oleg. It's simpler than it looks.
I think last time I wrote it down.
Yes, all the course of it. So, Dear Honor, I did reach out to Easy Messenger because my understanding is there was an original petition that was filed that I believe Mr. Perez Sr. was served on, but then there was an amended petition that was filed, and I have a return of service for the amended petition that does say Gerardo Perez, aka Gerardo Perez Jr. That is for February 10th, 2020. It does have the address of 12544 Setting Sun Drive. The description says it's a Hispanic or Latino male, 5'5", 170 with a goatee. And I mean, I'm looking at Mr. Perez here, and that does not look like he has a goatee. So I would be under the assumption that Mr. Gerardo Perez Jr. was served on that date. This is the only address that we have for Mr. Perez Jr. I have researched him, even the business that he received the loan for out of On Deck. All of the addresses I have say the 12544 Setting Sun Drive. I've received.
Miss Olette, will you please point me back? Okay, you're talking about, was it service on Mr. Perez Jr., is that right?
Yes, Your Honor, on February the 10th, 2020. And it was filed by EZM on February the 11th, 2020.
Don't I see that here?
And I have and it's file stamped. I have it. If I need to refile it with the court, I can. But I have the file stamp copy in front of me. Let me see if I can locate it as well.
I was the one that was served. It was dropped off from my front door. It was never served in person. I'm sorry to interrupt.
Let me look at this. So I'm looking at the affidavit of Robert Christie on the motion for default. Yeah, Miss Olette, can you point me to that?
Yes, I'm getting on Odyssey now to see if it's on here. And like I said, if not, I have it date stamped. I'm not sure why it's not on here. And it does say date stamped for the correct cause number too, 4211-2020. Yeah, okay, so if you see on 127-2020, it says citation Perez, Gerardo, and it says return 2/11-2020.
I'm sorry, say that again, please.
So on the, I don't know what your Odyssey looks like, but on mine, it's listed on 127-2020. The citation was issued. It says it was served on 2/10-2020 and returned on 2/11-2020. I don't know if you guys have a copy of that file stamped return.
Oh,
but
there it is.
Yeah.
Okay. Yeah, things are moving.
If I may interject,
No, Mr. Perez, just hold on, please.
Okay.
Let me sort through some of this.
Okay.
Mr. Medina, can you just send me the document that is filed, because I'm not used to seeing things over here.
Yes. Is there a specific, would you like me to email it to you?
If you'll email it to Ms. Hernandez, please. But I was asking the clerk, Mr. Medina, if you can send me the document that is filed under citation 1 on 1/27/2020.
Yes, Judge, I'll get it out to you.
Thank you.
Your Honor, I did have a question as well that I think you were going to be looking into at the last time this was when we appeared. And my question is regarding on the docket, it says an order of dismissal was entered on February 16th of 2023. So I just wanted to clarify what exactly that order of dismissal dismissed or referred to, since then
if I'm not mistaken, and let me go back to the entries because I've gone back and looked at this one too. The order of dismissal, I believe, was due to non-appearance by plaintiff. No, order for reinstatement is 2019.
Because I believe there was a failure to appear at the February 15th hearing, and then you entered an order of dismissal. And then several, back then into September of last year, then it got set for a hearing again for the receivership. So my concern is why it was dismissed and then reinstated.
Right.
I didn't see a motion to reinstate.
You're right. Mr. Medina, can you also confirm that after February 16, 2023, there was no motion to reinstate filed by plaintiff? And I guess I'll then ask Ms. Hernandez, in terms of the order setting hearing on 9/5/2023. Why did that happen? Did plaintiff file something and it wasn't closed out? And so we set a hearing.
I don't see a motion, Judge, after February 16. The only thing I see is a motion for appointment of a post-judgment receivership. That was filed November 1st, 2023, but it was via submission.
Okay, so Ms. Olette, I guess that's the point that Ms. Fisher is bringing up, is that after this case was dismissed back in February of 2023, although you all filed, and I'm not really understanding why it wasn't closed out, like this case was closed, why we then continue to have hearings and proceedings after the February 16th dismissal.
Right. And unfortunately, I can't answer that question. I was looking to see if we had sent an email to maybe someone, court clerk, coordinator or something that said, hey, this was DWOP. Can we get this back on the docket, or what the conversation was? So I was actually in the process of emailing my litigation assistant to see what happened with that, if we had any documentation of where the branch office didn't appear for that motion to appoint, how it was DWOP'd and how we got back on the docket. So I could get a trail with that. But if we need to do a motion to reinstate, we can, but I think we still go back to the issue of the Gerardo Senior versus Perez. I mean, Senior versus Junior still, though. And I think that's one of the biggest issues that we're trying to, rectify, so we know how to move forward. If it was DWOP'd and we can't get it reinstated, which I doubt we can at this point, because I think it's been too long. But with the motion to reinstate, let me see. And I don't know if our statute of limitations after on. I have to look and see what other avenues we have. But if we are able to get this back on track with this return to service, I mean, it was.
No,
I don't know.
No, I'm trying to figure out how we get restarted when this case was dismissed.
Let me see.
Between Mr. Medina, Ms. Hernandez, can you help me there?
Judge, from what I see on the actual hearing dates back in September, the order setting hearing for 9/20/23, the hearing was canceled and reset to October 4th. I don't know if there was another judge covering at that time, but there's been 3 settings for the post-judgment receivership.
Right, but there is no judge. Well,
they keep getting reset because every time we have these same issues coming up that have not been resolved, and then we reset them again.
And I think we all understand that. I think we're still just trying to figure out, was it DWOP'd or not, too? So we have 2 issues going here.
I also have a notice of default judgment that predates, right, the order of dismissal.
Yes.
Oh, excuse me, Judge.
Monday?
I'm sorry, Judge. So there was an order of dismissal filed on February 16, 2023 of last year, but they didn't proceed to close it because it says that the case was already closed on 06/24/2020 with a default judgment.
So if I may, Your Honor, I think this is where we also get confused. We'll have a judgment in place, and then we will try to file a motion to appoint a receiver. And if we don't appear, courts will try to DWOP it. And our understanding is you can't DWOP something that's already has a judgment on it. So when we call and tell the clerk that, then they reset us for a new date. And we keep getting reset because we keep having this issue with this junior versus senior. We already have a judgment in place. We're just trying to get a receiver to be appointed to recover that judgment.
Okay. All right. So we're gonna make this very, very hopefully simple now. Okay. What are we set for? We're only set for a status, right?
Yes, Your Honor.
We're set for a status. But basically you're seeking to appoint a receiver. So I presumably that's the hearing that was supposed to happen on February 15th.
Yes, Your
For
Honor.
which plaintiff did not appear. And
Correct.
so that motion to appoint a receiver is denied.
Correct.
The court is rescinding its order of dismissal of February 16th. Everything filed subsequent to February 16, 2023 is within the same vein of what that February hearing was. So now with the court's order denying that request, I believe that now closes the case for everyone. And we no longer have an issue. I'm not looking at the issue of if Mr. Junior was served vis-a-vis Mr. Senior. Mr. Pettis.
If you would allow me real briefly, I have a
No, sir,
video.
because you're not a party in this case, and so
But I was
I'm going
served. I was served, and I have a video where I was served. A heavy-set man came to my house and left the paperwork in my front door. My son was never served. A heavy-set man. I have the video where he dropped off the. So I don't know how they're claiming that he was served.
I am going to mute you because I've asked you repeatedly to not speak over the court, and you continue to do that. So I don't know where your son is, how we got to the default judgment, who his attorney was, if he had one. That's his argument to make. We're well beyond that. There has been a default judgment entered in this case. Plaintiffs have asked for a receiver. I have denied that request. And for my purposes, this case is closed. You can talk to Mr. Fisher, to your son, or anyone else about how service may or may not have been attempted. What I have is documentation showing that it was served on an individual that was not you, that went by Gerardo Perez Jr. Okay? That is not for you to litigate per se in your capacity. It is for your son. So thank you for your time, Ms. Fisher. I want to thank you continually because you've been quite instructive in helping us all, and Ms. Olette, you as well, as going back and seeing what happened here. But in any event, the court has made its ruling, and for our purposes, this case is closed.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
May we be excused?
Have a good